Right. Well, I'm going to start this webinar now. There may be more people arriving, but I think it's best just to get on a little bit. I'm going to start by saying that in June of this year, the seven-man board of the Supreme Court came up with two important decisions about the scope of the duty of care and damages in professional negligence cases, both of which consider in some detail the House of Lords' famous decision back in 1997 in the Samco case, in a judgment or speech given by Lord Hoffman. And those two cases are Manchester Building Society v. Grant Thornton, which is a case which involves accountants' negligence, and Conor versus Meadows, a case which involves clinical negligence in the professional negligence context. And may I say thank you very much to all those attending. It's very good to see you, and I've seen one or two people whose names I recognise, which is obviously even better as far as I'm concerned. And I'm delighted to see you all. And I'm also delighted to be making this presentation with Sara Ibrahim, who I know has considerable expertise in the matter on which she's going to be talking about. Broadly, I shall be talking first about the Manchester Building Society case, and that will be for about 25 minutes or so. And then Sara Ibrahim will talk about the Conor Meadows case, which will be for about 15 minutes. The two cases were decided together, and in large part, the principles they express are pretty well the same, but it is important to see how, and interesting to see how they are applied differently to the respective cases. At the end, I hope we'll have about 15 minutes or so for questions and answers to be given. Those questions, I understand, are to be given by chat. So if anyone has any questions as the conversation goes along, please don't hesitate to send us chat messages, and we shall do our best to answer the questions, which no doubt will be difficult and probably beyond our means, or my means in any event. But anyway, please do ask as many questions as you like, and we'll pick out those which are the easiest to answer. The question of damages for valuers' negligence has long given rise to difficulties, and the question was reviewed in detail in 1994 by a strong Court of Appeal in a series of cases in which the lead case was Banque Bruxelles Lambert versus Eagle Star Insurance, which considered authorities from all around the Commonwealth. A vast amount of authorities was considered, and the court was Sir Thomas Bingham, Master of the Rolls, later Lord Bingham, Lord Justice Rose, and Lord Justice Morritt. And that case concluded, or that series of cases concluded, court concluded, that in a no transaction case, that is to say, where the lender would not have entered into any transaction at all with the borrower, but for the valuer's negligent overvaluation, the lender is entitled to recover, in general terms, 1, the total capital sums laid out, less 2, the net sums eventually received on a forced sale of the property. The reason, the court said, for this was that the starting point in any assessment of damages was that its purpose was to put the victim in the position he would have been in, but for the tort or breach of contract. Therefore, subject only to the usual questions of causation, remoteness, and mitigation, the lenders were entitled to recover all their losses. In particular, the Court of Appeal rejected two arguments. First, the argument that the valuer is not responsible for any loss that is caused by movements in the market, because, the Court of Appeal held, such movements in the market are always reasonably foreseeable. Secondly, the court rejected the argument that the valuer's liability should be limited to the extent of the overvaluation, because the loss the lender suffers is a single unitary loss, and it is artificial to split up the loss. It is one transaction and one loss, the Court of Appeal held at page 421G and 407D in the report in 1996 Queen's Bench cases. The valuers appealed to the House of Lords, who took a different view in a speech given by Lord Hoffman, with which all the other members of the House agreed. Now, his speech falls into two parts. The first explains why, in principle, it is wrong that valuers, in the normal case at least, should be liable for the totality of the loss caused by a drop in the market. The second part explains how the correct measure of damages in a negligent valuation case is to be worked out in practice. Now, the first part makes a number of general points. First, the starting point was not, as the Court of Appeal had held, that the claimant was entitled to be put in the position he would have been in but for the wrongdoing. On the contrary, said Lord Hoffman, the proper starting point is, quote, to decide for what kind of loss he, the plaintiff, is entitled to compensation. A correct description of the loss for which the valuer is liable must precede any consideration of the measure of damages. See 1997 appeal cases at page 211b. The second general point Lord Hoffman made is that in considering the correct starting point, there is a difference in principle between two types of case, namely, cases where the advisor is advising the client generally as to whether or not to enter into the transaction, for instance, an investment advisor advising on what investments a client should buy, and secondly, cases where the advisor is merely providing one of many bits of information to his client, like a valuer to a bank on a loan, in order to enable the client to decide whether or not to enter into the transaction, that is to say, to grant the loan and to grant the mortgage. In the former case, Lord Hoffman said, the negligent advisor is liable for all the losses to the client because his duty is to consider all the risks of the transaction. So if any of them materializes, it is just that he should pay all the losses suffered by the victim as a result of entering into that transaction, subject only to the usual questions of remoteness and mitigation. But in the latter case, the scope of the advisor's duty is simply to assess a particular risk. And so he is not assuming any duty to be liable to the client for the risks which the client himself is prepared to take on if the information turns out to be correct. On the contrary, said Lord Hoffman, the scope of his duty is that he is liable only for those consequences which are attributable to that which made the act wrongful. In other words, in the case of a negligent valuer, he is liable only for the consequences of the information being inaccurate. It would not be fair and reasonable, that's exactly the phrase used by Lord Hoffman, to impose a wider duty than that. And so, for instance, by way of example, if the lender was prepared to lend, say, £8 million on the basis of a £10 million valuation by the valuer, he is obviously prepared to take the risk that a fall in the market might bring the property down to £3 million, in which case he would lose £5 million. That is to say, the 8 million advance less the 3 million he eventually gets back. But as the lender is prepared to take that level of risk, even if the valuation is correct, it is not fair and reasonable that he should be made liable for this part of the loss, as if he, rather than the lender, had taken on the risk for this part of the loss. And to illustrate his point, Lord Hoffman gave his famous example, or parable, as Lord Sumption later put it in a later case, of the mountaineer. He asks his doctor to advise him on whether his knee is good enough to go climbing, and the doctor negligently says yes. He then goes on the expedition, and there he suffers a fall, which is in no way related to the problem with his knee. But for the doctor's negligence, he would not have gone on the expedition. But the doctor wasn't advising him generally about the wisdom or otherwise of going on the expedition, but just on the point about his knee. But the point he got wrong had nothing to do with the accident. Surely, therefore, the doctor cannot, in any sensible view, be liable for the injury. Now, it will be seen, and this is the point which is later considered in the two cases which Sara and I will be talking about, that this test involves asking, quote, a counterfactual question in order to determine what falls within the scope of the advisor's duty of care. That is, you ask, what would the position have been if the information provided had actually been accurate? If, and to the extent, as in the mountaineer example, the same loss would still have occurred in any event, then there is no cause of action for that loss. The second part of Lord Hoffman's speech then explains the correct measure of damage, and that is that the lender is entitled to damages to the extent that the valuation was wrong, which in most but not all cases is equal to the amount of the overvaluation. See page 219G. As Lord Hoffman later explained shortly afterwards in a related case, Nye Credit Mortgage, 1997, 1 Weeklies, 1627, this is because, and I quote, the valuer is responsible only for the consequence of the lender having too little security. Now, Lord Hoffman then works out how this was to apply in the various cases before the House of Lords in the Samco case. In most of the cases, the lender's actual loss, that is to say, the sum advanced less sums recovered, exceeded the amount of the overvaluation. So the damages were reduced by the House of Lords to the amount of the overvaluation. This being the measure of loss, because to this extent, the information provided by the valuer was wrong. However, in one case, the lender's actual loss, that is to say, sum advanced less sum recovered, was about £9.6 million, which was lower than the £10 million overvaluation. The valuer had rather brilliantly come up with a £15 million valuation as against an actual value of £5 million. Therefore, the award of £9.6 million was allowed to stand, because if the lender had had that extra £10 million margin, as he thought he had, this would have been sufficient to cover the £9.6 million loss. I emphasize how all this was worked out in reality, because although Lord Hoffman resisted this notion in his speech and in a later speech, measuring the damage by reference to the overvaluation does operate in practice as a sort of cap on the damages to be recovered. What the court was doing in BBL, Samco as it's called sometimes, was a quite novel exercise. First of all, it assesses the real actual loss in the way that one normally assesses loss. You look at the sums advanced, and then you say to yourself, well, what was recovered? And then you just take the difference with other bits and bobs added in. Having first of all asked that question, it then asks a totally different question, namely, how much of this loss falls within a completely different test, which bears no relation to the loss itself, namely, what was the extent of the overvaluation? And it's fair to say that I think it is a bit of a brain teaser, but on the whole, the courts have gone along with this test. After BBL, there are a number of cases which worked out its implications, in the course of which doubts were expressed about the appropriateness of a strict dividing line between information cases, which Lord Hoffman had talked about, and advice cases on the other. The courts held that the real distinction was between cases where the advisor was advising on a limited aspect of the transaction and where he was advising generally on whether the transaction should be entered into. There are two cases, however, which should particularly be noted as they are stark illustrations of the principle in BBL, Samco. The first is a case called Anaco Reinsurance Underwriting versus Johnson, 2001, two All England reports, commercial reports 929, in which a broker reported to his client that he had successfully reinsured a book of excess business loss to the client who intended to proceed only if he could get reinsured $11 million of the risk. In fact, the broker did not present the risk fairly to the reinsurers, with the result that the reinsurance or the retrocession was later avoided. Now, the claimant claimed his entire loss of $35 million, which he had incurred on the reinsurance, on the basis that he would not have entered into any reinsurance at all if he hadn't been reinsured about the retrocession for $11 million. The House of Lords, by a majority, held that he was entitled to recover all $35 million loss, even though he was prepared to accept, go into the reinsurance with just $11 million of cover. This was because this was an advice case, because the broker's duty extended to telling the insurers that the market for reinsurance had taken a highly adverse assessment of the reinsured risk, which he failed to do. So it's a striking example of how the wrongdoer can be liable for a much larger sum than he might have expected. He's asked to reinsure $11 million. He lands up having to pay $35 million. The second case, which is worth noting, is a case decided in 2019, I think, 2018, called Hughes Holland v. BPE Solicitors, and in a judgment by Lord Sumption, which is well worth reading, where he revisits all the general principles of the Samco BBL case and applied the counterfactual test to a claim against a firm of solicitors. He held, amongst other things, that the claimant's claim against the solicitors had to fail because the solicitors, even if the solicitor's negligent misstatement about the intended use of a loan that he, the claimant, was intending to make, the claimant would still have suffered all the loss he did actually suffer in making the loan on an unsuccessful development. I now come to the Manchester the Building Society case. The facts are somewhat complicated, but they can be summarized as follows. The Building Society advanced money on what are called lifetime mortgages. That is to say, loans designed to release equity in the borrower's home, granted to people over the age of 50. The Building Society charged interest at a fixed rate, but neither the interest nor the capital sum was repayable until the borrower died, moved out, or chose to redeem the mortgage. Until then, the interest was compounded. The borrowers were all over 50 and they lived in the UK or Spain. The total loans that the society acquired or issued like that came to about £100 million. Now, in order to fund the loans, the society borrowed sums at variable interest rates on the market. And to protect against the risk that the variable interest rates on the borrowing would exceed the fixed rate received on the lifetime mortgage loans, the society entered into a series of interest rate swap contracts under which it agreed to pay a fixed rate on the notional sum in return for the counterparty's agreement to pay a variable rate. So the intention was that the variable rate payable by the swap counterparties would match the variable rate paid by the society to third parties to borrow money. The interest payable to the society by the mortgage borrowers would exceed the interest rate payable by the society under the swaps. And therefore, when the lifetime mortgages were eventually redeemed, the society would be guaranteed to make a profit. If it sounds too good to be true, it is too good to be true. The society was required, now the important point in the case was that the society was required to prepare its accounts in accordance with what are called the International Financial Reporting Standards, which require swaps to be accounted for on the balance sheet at their fair value, which that is to say, their mark-to-market value. Now, the mark-to-market value is the price at which the swap can be traded at any given date in the market. Now, this price tends to be volatile because it will vary depending upon movements in the interest rates. If you are on the right side of the swap, so to speak, and the movement in interest rates means that for the foreseeable future, you will be the net recipient under the swap, it will have a positive value, maybe a very big positive value. But if the movements mean that you will be the net payer under the swap, it will have a negative value, and perhaps quite a substantial negative value. Now, however, such volatility could be mitigated if the society could properly use what is called hedge accounting. If that was permitted, the value of the lifetime mortgages could be offset against the swaps so as to reduce the volatility that would otherwise have to be recorded in the society's accounts for the swaps. In other words, you treat everything as set off one against the other, so there's no real volatility. Now, in 2006, Grant Thornton advised the society that it could apply hedge accounting to the lifetime mortgages and swaps, thereby advising them implicitly that the hedge was, quote, highly effective in achieving the object of having the mortgages offset against the swaps for accounting purposes, so as to remove any volatility in the accounts. Now, it did this even though there was a serious mismatch between the loans and the swaps. This was because, in many cases, the loans were for terms of 50 years, which were wrongly matched with swaps of 50 years. The match was wrong because although the swaps would definitely last for 50 years, the loans in practice would have to be replaced much earlier than that with substitute loans. That, of course, is because most of the people who had these mortgages were over 50 in the first place. So they'd have to live to about 100 for the mortgage, the life of the mortgage to coincide with the life of the swap. And the problem was that if the loans had to be substituted, it was impossible to tell when they would be substituted. And so you couldn't tell whether the substitute loans with equivalent fixed rate interest could ever be obtained in 20 or 30 years' time. Now, no one noticed that at the time. And in reliance on the advice given by Grant Thornton, the Building Society, retained some of the swaps and lifetime mortgages it had already entered into, and entered into yet more lifetime mortgages and swaps from 2006 to 2011. It also prepared, with Grant Thornton's blessing, its financial statements in these years on the hedge accounting basis. Now, after the 2008 financial crisis, interest rates, or variable interest rates, fell. And so the mark-to-market value of the society's interest rate swaps, taken on their own, became severely negative, because the fixed rates which the society had to pay under them now became much higher than the variable rates they would receive. However, this liability, or so they thought, was offset on their balance sheet, because, as they thought, they could make a corresponding adjustment to the reported value of their lifetime mortgages using hedge accounting. How anyone could have thought that, I don't know, but that is what they all thought. In 2013, however, about 5 years after the crash, Grant Thornton told the Building Society that, in fact, it was not and had never been entitled to use such hedge accounting in the preparation of its accounts, and that the Society had to account for the fair value of the swaps taken on their own from 2011 onwards, without any reference, or without reference to any supposed hedging against the lifetime mortgages. That in turn meant, A, the Society's previously reported profits of 6.35 million for 2011 had to be restated as an 11.4 million loss. B, its net assets were reduced from 38.4 million to 9.7 million. And C, its previously reported, quote, capital headroom of 20.4 million had to be altered to a capital deficit of 17.9 million. Now, this reduction in capital on its reported accounts meant that the Society had insufficient regulatory capital, and therefore in June 2013, it was forced to terminate its swap contracts early at a cost of £32.5 million, being the negative mark-to-market value the swaps then had, because of course the variable interest payable under them for the next 40 years or 37 years or so was going to be infinitely higher than the fixed interest rates. They also had to pay, the Society also had to pay a sum of about £300,000 to the counterparties in order to effect the early termination. Now, the Society also got rid of its book of UK lifetime mortgages at a premium of 3.5 million. That's at a profit of 3.5 million on the par value. And although it didn't get rid of its Spanish lifetime mortgages, it was common ground that they had made a profit of about £2.5 million, if and when it did get round to selling that book of mortgages. Now, at first instance, the Society brought a claim in negligence against Grant Thornton on the basis that it had relied on its advice, which principally consisted of the £32.5 million they had to pay to terminate the swaps in 2013, along with a claim for about £300,000 for the costs of terminating the swaps and miscellaneous small expenses. Grant Thornton admitted negligence on two main grounds. First, they admitted there was a significant mismatch between the 50-year duration of many of the swaps and the much shorter expected duration in real life of the lifetime mortgages. Secondly, they admitted that you could not use hedge accounting in any event if you were relying on substitute mortgages to take the place of existing mortgages, which were for less than 50 years. Now, you might think on the basis of those facts, this was an open and shut case. Although it is true Grant Thornton was advising on only one aspect of the relevant transactions, that is the availability of hedge accounting or otherwise for this type of business, and it wasn't giving general advice as to whether it was wise to enter into this transaction, the Society definitely did rely upon its advice in order to embark upon a disastrous business model, in the mistaken belief that their respective rights and liabilities to their various counterparties under the mortgages and the swaps could all be satisfactorily hedged, one against the other, so that taking in the round, they, the Society, were operating at a relatively limited risk, without risk to its regulatory capital. Applying the counterfactual, what if Grant Thornton's advice from this point had been correct, they would not have suffered any loss, and so the loss was within the scope of the duty. However, Grant Thornton came up with a number of defences. First, they argued that the Society had been contributory negligent because they should themselves have realised that the fixed rate liabilities under the 50-year swaps could not be covered by the fixed income under the 50-year loans, because those loans were in practice unlikely to last for 50 years or to be easily substituted. Secondly, its finance director should anyway have realised that hedge accounting wouldn't be available for this sort of caper. Now, the judge accepted that, and he held that the society's damages therefore fell to be reduced by 50% for contributory negligence. Second, Grant Thornton argued that they could not be said to have, quote, assumed responsibility for the society's main loss of 32.5 million odd, because that loss flowed from market forces for which Grant Thornton had not assumed responsibility. The judge, Mr. Justice Tier, accepted that argument, and accordingly he dismissed the claim and awarded the society just £316,000 odd for their costs in terminating the swaps early, less 50%. On the appeal to the Court of Appeal, the court upheld the judge's judgment, but for different reasons. It held, agreeing with another of Grant Thornton's arguments, the following. First, this was not an advice case, but an information case. Second, Grant Thornton was therefore legally responsible only for the foreseeable consequences of its information or advice being wrong. Thirdly, the wrongfulness of the information or advice had forced the society to close its swaps early when it did, for regulatory capital reasons. But this did not of itself mean that the society had suffered a loss. To show that, the society had to prove that it would have been better off had it been able to continue to hold these loss-making swaps. And it had failed to show that on the findings of the judge. Therefore, the society had failed to show that it had suffered any loss by reason of the wrongfulness of the advice. In other words, it would have been in the same position even if the advice had been correct. Therefore, the loss fell outside the scope of Grant Thornton's duty of care. In short, the Court of Appeal, applying the counterfactual test, held that the only consequence of the advice being wrong was that the society was forced to close its swaps early in June 2013, but that of itself did not put it in a worse position than it would have been in had it been able to hold on to them. So it hadn't proved it had suffered any loss within the scope of Grant Thornton's duty of care, notwithstanding the fact it lost £32.5 million. Now, the appeal to the Supreme Court was heard together with Conor Meadows by a 7-man board because of the importance of the issues raised. And on the society's appeal, their lordships were agreed that the appeal should be allowed and that the society was entitled to damages of £32.5 million odd, subject to A, the credit being given for the total of the profits of about 6.8 million made on the lifetime mortgages, and B, a deduction of 50% for contributory negligence. However, the board was divided as to the correct analysis. The majority judgment was given by Lords Reid, Hodge, Lady Black, Lords Kitchen and Sales. They held that there were generally 6 considerations which should guide a court in a negligence claims. These are repeated in the Khan case with which Sara shall be dealing, so I won't set them out here, but they are rather important for any future, anyone dealing in future with professional negligence cases. They went on to approve, in general terms, the main parts of Lord Hoffman's speech in the Samco BBL case, as expanded upon by Lord Sumption in the Hughes-Holland case I mentioned earlier. That is to say, you must consider, quote, the purpose of the duty judged on an objective basis by reference to the reason why the advice has been given. That in turn means that one looks to see what risk the duty was supposed to guard against, and then looks to see whether the loss suffered represented the fruition of that risk. In other words, perhaps put more simply, is there a sufficient nexus between the harm for which the claimant seeks damages and the duty of care? Secondly, they confirmed that if the advisor's duty is to guide the whole decision-making process, his responsibility extends to the decision itself, and so if he negligently assesses one risk, he has understated the overall risk of the transaction, and he is liable for the loss caused by the client entering into that transaction, even if the loss resulted from some other risk which he had correctly assessed. That's in paragraph 20. Thirdly, they confirmed that if the duty is simply to contribute part of the material to be relied on by the client, the professional is liable only for the financial consequences of that information or advice being wrong, and not for the financial consequences of the claimant entering into the transaction, see paragraph 21. However, the majority then went on to qualify Lord Hoffman's speech in three important respects. First, when considering cases like this, it is generally more appropriate in practice to start by considering the but-for test, contrary to what Lord Hoffman said, and to identify what losses were in fact caused by the defendant's wrongdoing. In other words, to identify what they called, quote, the basic losses, before asking whether and to what extent those losses fall within the scope of the duty of care. See paragraph 12. Secondly, the distinction, they said, between advice cases and information cases is too rigid and liable to mislead, because there is a wide spectrum of cases from giving full advice with responsibility for everything to just one tiny bit of information. See para 18. So, as suggested by Lord Leggett in his speech, the use of this distinction should be, quote, dispensed with, para 22. Third, the majority held, that the counterfactual test, i.e. would the loss still have been sustained if the limited information advice had been correct, is merely, and I quote, a useful cross-check in most cases, but it should not be regarded as replacing the decision that needs to be made as to the scope of the duty of care. See para 23. In particular, they went on to note that a problem with the counterfactual test is the danger of, quote, manipulation of the parameters of the counterfactual world. And, quote, the more one moves from the comparatively straightforward type of situation in the valuer cases, the greater scope there may be for abstruse and highly debatable arguments to be employed about how the counterfactual world should be conceived. One has to take care, therefore, not to allow the counterfactual analysis to drive the outcome in the case, para 26. Therefore, they continued, when applying a counterfactual test appears to lead to a different result from simply examining the purpose of the duty of care, a choice has to be made. And then they continued, and in our view, it should be in favour of a clear adoption of the purpose of the duty of care as the relevant test. The cross-check is not to be treated as the foundation of the analysis. See para 27. The board then went on to apply that to the facts of the case. And they held in summary that the society had a distinct commercial interest in the accounting treatment of its loans and swaps, because if it could adopt the hedge accounting method, this would reduce the volatility that would otherwise have to be shown in its accounts, and therefore the amount of regulatory capital the society would need to have in order to keep trading. Secondly, Grant Thornton realised this and realised that the society would need and rely on its advice in order to decide whether or not to go ahead with its business model, which involved entering into more swaps and lifetime mortgages. Thirdly, Grant Thornton repeated this advice every year it approved the society's accounts. And fourthly, the purpose of the advice was clear. That is to say, the society looked to Grant Thornton for technical accounting advice, whether it could use hedge accounting in order to implement its proposed business model within the constraints arising by virtue of the regulatory environment, and Grant Thornton advised that it could. That advice was negligent. It had the effect that the society adopted the business model, entered into further swap transactions, and was exposed to the risk of loss from having to break the swaps, when it was realised that the hedge accounting could not in fact be used, and the society was exposed to the regulatory capital demands which the use of hedge accounting was supposed to avoid. That was a risk which Grant Thornton's advice was supposed to allow the society to assess, and which their negligence caused it to fail to understand. Now, notably, in making this analysis and finding in favour of the society, the majority did not attempt at all to use any counterfactual test, and noted that Lord Leggett's attempt to do so was, quote, sophisticated. See paragraph 26. Now, Lord Leggett's approach was slightly different because he was prepared to adopt the counterfactual test, although he noted that it was sometimes difficult to apply, paragraph 100, and he accepted that it should not be assumed that it is necessary or helpful to apply a counterfactual test of the kind formulated by Lord Hoffman in every case, as it is simply one means of assessing whether there is a sufficient causal connection between the subject matter of the defendant's advice and the claimant's loss, so as to justify the conclusion that the loss falls within the defendant's duty of care. But he noted two examples where it is useful. First of all, the valuer's negligence cases, and also in Lord Hoffman's example of the mountaineer's knee, and also in Conor Meadows, as Sara will discuss. He then went on to hold that on a proper assessment of the counterfactual test, Grant Thornton was liable because on the proper understanding or on the proper counterfactual test, Grant Thornton had advised that the hedges were in effect highly effective, or the hedges were highly effective, and that the accounting would be satisfactory, the consequence of which was that there shouldn't have been any regulatory capital problem at all. That information or that advice was wrong, and therefore the loss was related to the wrongfulness of the advice. Lord Burroughs' analysis is very clear, expressed in his own words, and is to a large extent the same as the majority's. And he agreed that the counterfactual test can lead to problems. In particular, he noted one problem where he says it is just completely misleading. And that is the case of a negligent audit report, when, as a result of the report, a company pays out a dividend to shareholders. Now, it is established law that in such a situation, the company can sue the auditor for damages equal to the payment out to the shareholders. But if you applied a counterfactual test and asked what would have happened had the audit been correct, such as to entitle the company to pay out the relevant dividends, the company would still have paid out the dividends in any event. And so one would end up with a rather peculiar conclusion that the auditor therefore owed no duty of care to the company in respect of that loss, if you take the counterfactual test to its limit. This, said Lord Burroughs, gives one pause for thought as to whether the counterfactual test is always appropriate. In short, the overall result of the Manchester Building Society case is to reaffirm the Samco or BBL principles, but to put into second place the counterfactual test. No longer will we have to go through the contortions, save in very simple cases, of trying to work out what would have happened to the counterfactual world and ask ourselves, now, what if the advice or information had actually been correct? Would the loss have still been suffered? Instead, you simply look at the purpose of the scope of the purpose for which the duty is being imposed upon the defendant, and whether or not there is a sufficient nexus between the wrongfulness of his advice and the loss that has been sustained. And I shall now pass to Sara Ibrahim.
Thank you very much, Peter. I'm just going to share some slides. So, as Peter will have explained, I will be dealing with the case of Conor and Meadows. Again, as you have heard in Peter's very helpful and fulsome talk, that was heard at the same time as the Manchester Building Society case. And I've put the citations on the screen for you there. Now, Conor Meadows is actually a clinical negligence case, but it's quite clear that the treatment of the Supreme Court means that the decision in Conor Meadows has wider ramifications for professional negligence and the calculation of damages. And as Peter has made very clear, the case of, as you can see there, Samco was considered extensively by the Supreme Court. So what was Conor and Meadows about? Putting it very simply, Conor Meadows is categorised as what's called a wrongful birth case. So for those of you who do not encounter clinical negligence in your practice, what happened on this occasion is Miss Meadows visited her GP and she wanted very specific advice as to whether she was the carrier of the haemophilia gene. She was wrongly advised that she did not, in fact, carry the gene. So she became pregnant and she gave birth to a son who was born with haemophilia and autism. Now, the judge at first instance found that if Miss Meadows had been aware that she was a carrier of that gene, then she would have terminated the pregnancy. Now, the reason that there was a dispute in this case, you will see from the figures, is that there is a significant difference in the cost of raising a child with haemophilia, which was about 1.4 million. These figures were agreed by the parties, whereas raising a child with autism and haemophilia was £9 million. Now, the first instance judge is, in fact, a very well-known clinical negligence practitioner and applied what is called the but-for test that Peter has already touched upon. And applying that test, it was held that were it not for the defendant's negligence, then the child would not have been born. So there was a very significant award of costs of the £9 million. This went up to the Court of Appeal, who found that, in fact, this was incorrect and damages ought to be 1.4 million. In essence, that the award ought to only reflect the damage for the haemophilia. So in giving the decision of the court, you will see there that the test applied was that identified by Lord Hoffman in Samco, which Peter has very helpfully gone through already. And it says here in the judgment that given the specific inquiry of the respondent's mother, namely would any future child of hers carry the haemophilia gene, it would be inappropriate and unnecessary for a doctor at such a consultation to volunteer to the person seeking specific information any information about other risks of pregnancy, including the risk that the child might suffer from autism. I just pause at this stage to say that it was agreed by the parties that there was no connection between autism and haemophilia. So the first instance judge had in fact been found to have erred in their finding that defendant was liable for a type of loss because it fell outside the scope of their duty of care. We then get to the Supreme Court. Now, at first instance, you will see from this slide that the claimants argued that Samco was irrelevant for cases of clinical negligence. And they said that the focus ought to have been on the failure of the doctor to provide Miss Meadows with the information needed to make an informed decision on whether to continue with the pregnancy. And indeed, the appellants very much relied on the fact that there was what they termed an imbalance of knowledge and power between Dr. Khan and the patient, and therefore this wasn't something that sat within the cases of Samco, Hughes and Holland, etc., where you may have had parties where there was more parity. The defendant instead took a far more structured approach and suggested those 6 questions. And you will see as we move through that these 6 questions were perhaps more closely aligned to the ones that the Supreme Court ended up deciding on. Now, Peter mentioned that there were 6 principles, and these 6 principles or questions that were identified to clarify the scope of duty are going to be essential for any professional negligence practitioners going forward. So what were these questions? Firstly, what they call the actionability question. Have you suffered some harm which leads to an actionable claim? That it is going to be, I would suggest, quite straightforward. 2, and this is important here, and that is the scope of duty question. What exactly was the scope? And this, for reasons we'll see on the next slide, does sit very closely with question 5. But before that, dealing with their question 3, was there a breach? Again, this is something that it is going to be relatively straightforward in most professional negligence claims. The 4th question is what they referred to as the factual causation question. Were there in fact damages that flowed from any act or omission of the defendant? And then 5, is there a sufficient nexus between a particular element of the harm for which the claimant is seeking damages and the subject matter of the defendant's duty of care? So that is why it is very important to have a firm and clear view of what the scope of the duty is. And then 6, this is referred to as the legal responsibility question, and you will be familiar with a lot of the principles there. For example, are damages too remote? Has there been a novus actus that has intervened? Or have you had issues that can be raised, for example, mitigation of loss. So coming to Samco, the scope of duty principle, or the Samco principle as they referred to it in Conor Meadows, was that a defendant is not liable in damages in respect of losses of a kind which fall outside the scope of his duty of care. So whilst this may seem a relatively straightforward principle, it is one that leads to a lot of confusion if that scope of duty isn't properly defined at the outset. Now, the Supreme Court were very keen to emphasise this wasn't a principle that was decided in Samco, but predated it. And the reason I have added this section from the judgment of Denning, Lord Justice Denning, as he then was in 1953, is because of its admirable clarity. And Denning said in the case of Rowe and Minister of Health, it seems to me that they are simply three different ways of looking at one and the same problem, starting with the proposition that a negligent person should be liable within reason for the consequences of his conduct. The extent of his liability is to be found by asking the one question: is the consequence fairly to be regarded as within the risk created by the negligence? If so, the negligent person is liable for it, but otherwise not. We then come to the Samco Counterfactual, which again, Peter has already touched upon. Now, what is the Samco Counterfactual? That is, what would the claimant's losses have been if the information which the defendant in fact gave had been correct? And that obviously is within the scope of this particular case, i.e. Dr. Khan, and whether they gave the correct information about the haemophilia gene. So this is intended to allow the court to ascertain the loss which is attributable to the information being wrong. And I've put in square brackets there the paragraph of the decision for you to look at. Then, as they said in the linked Manchester case, the Samco Counterfactual is a tool for lawyers to cross-check after answering those 6 questions that I have already taken you through. And it's interesting that the Supreme Court has dismissed criticisms of the Samco so-called cap that arises because of the mathematical imprecision that may result. And they approved specifically what Lord Hobhouse had said earlier, the case there of platform home loans, which I have referred to, that essentially that this counterfactual and the cap that it leads to is a robust way of applying the scope of duty principle. So they then went through the 6 questions and the facts of the matter of Conor Meadows, and this is what they found. The first point is pretty straightforward here, that the economic costs of caring for a disabled child did lead to an actionable claim. The scope of duty question, that question 2, which is quite key to all of this, was answered by addressing the very specific purpose for which Miss Meadows had approached Dr. Khan in the first place, namely to know, did she or did she not carry the haemophilia gene? And the respondent owed a duty of care to take reasonable care to give accurate information or advice. And that accurate information or advice related to whether she was a carrier of that gene. 3, again, quite straightforward in this case because it had actually been accepted that there had been a breach by Dr. Khan, though limited to the failure to properly advise on whether she carried the gene. And then point 4, there was a causal connection there between Dr. Khan's mistake and Miss Meadows' decision to give birth to the child. And there, that test in wrongful pregnancy cases, that she lost the opportunity to terminate the pregnancy. Moving on to the question 5, the scope of duty question. And again, this has to be read in accordance with question 2. This relates to the duty nexus question. So the law did not impose any duty in relation to unrelated risks which might arise in any pregnancy. It followed that the responsible was only liable for the costs associated with the haemophilia. Now, in this case, the Samco Counterfactual tool was applied. And in fact, as Peter has already said in the Manchester case, there was a pretty complicated counterfactual scenario which had been put to the Court of Appeal in the Manchester case, which, if you look at the judgment of Lord Leggatt, he was very critical of, and in essence goes as far as to suggest the Court of Appeal had been led astray by some of that counterfactual analysis. But when it comes to a case like Khan, and he specifically cross-refers in his Manchester judgment to Khan, he said this counterfactual tool is actually very useful. So when applied correctly, it can be very helpful, namely that it enabled the court to understand what the scope of duty actually was, the counterfactual, that it related to the haemophilia and not to the autism. The Supreme Court then looked at the question of remoteness, and in the case of Khan and Meadows, which was significantly more factually straightforward than the Manchester case, there weren't questions of remoteness, mitigation of loss, etc., that needed to be considered. So as in the Manchester case, you have different approaches of Lord Burrows and Lord Leggatt. So Lord Burrows, who was more in tune with the majority of the Supreme Court, says that the Samco principle should apply to information and advice cases, including those given by doctors. And that is the term he uses, though what Peter has said is absolutely correct. Those information and advice cases are not to be seen as polar opposites anymore, but rather on a continuum. He did disagree, though, with Lord Hodge and Lord Sales about what he termed the novel approach. And that novel approach is the 6 questions that I have taken you through. Though if you are approaching professional negligence claims in future, those novel 6 questions are the ones that you ought to be looking at. Now, Lord Burrows said that he had an alternate 7 elements, and those elements are going to be well known to you that have practiced in tort. Was there a duty of care? Was it breached? Was there factual causation? Remoteness questions, legal causation. Was the damage or loss within the scope of duty of care? And the defences questions. So there are some differences there, but it is those 6 questions that ought to be the ones you focus on. Now, with Lord Leggatt, he does disagree with what he refers to as the structured approach to the negligence questions. He instead emphasises the causal connection between the loss and the subject matter of the defendant's duty. Though I again pause and say it is interesting that he also, Lord Leggatt, says in his judgment that as a doctor's duty will sometimes extend to addressing a matter on which the patient had not asked for advice, but which the doctor recognises or ought to recognise poses a material risk to the patient. So that is quite interesting there, and I think it could impact on other types of case, because there will be certain professionals whose expertise means that even if they are not specifically asked about something, ought to know that there is a risk that is so material that they ought to inform their client, or in this case, patient. And I would say for those of you who are interested, there are quite a few slightly panicked articles from the clinical negligence community where they have very much seized upon that paragraph from Lord Leggatt's judgment. In conclusion, I thought it may be very interesting to say that there is, in fact, in New South Wales, so we're talking about Australia here, similar grappling with the same kinds of principles that the Supreme Court looked at. And in their cases, they apply a 2-limb test, where they look at the but-for test as being the first part of that limb, which was looked at in the Khan case at first instance, but they go on and look at a second limb of the test, which is whether or not and why responsibility for the harm should be imposed on the negligent party. Now, the policy in New South Wales and Australia more broadly behind that is to ensure that the duty is to avoid the consequences of a particular physical injury, the risk of which the patient has not been prepared to accept. So it ought to be seen as very likely, following on from this particular case, that there will be an attempt to extend this principle to all professional negligence matters. So even those who have sought to subdivide professional negligence from clinical negligence to solicitor's negligence or auditor's negligence, etc. The Supreme Court quite clearly sets out that there is a universal standard. But as I have touched upon and the comment made by Lord Leggett, query if now there can be distinctions drawn between commercial clients who will be expected to have a very different attitude and knowledge of the risks that they're taking, and say consumers or patients.
Well, Sara, thank you very much indeed for that extremely lucid talk. There's one thing you said, which the Supreme Court said, which is totally untrue, which is that anyone had ever dreamt up any test like Lord Hoffman had in the Samco case. It's totally novel. And Lord Sumption actually says in one of the cases subsequently, it was new, although there had been a few cases that might have just about suggested it. And Lord Hoffman's solution wasn't even argued for by anyone. It was his idea, basically. No one else's. And the point was, the general view was that once you're liable for a loss, you're liable for all of it, subject to questions of foreseeability. Simple as that. And that's why the Court of Appeal decided the other way. But I don't know if people have any questions. For myself, I still find it quite a difficult doctrine to get my head around the whole time. The counterfactual always throws me. I always try to forget whether it's supposed to come up with the same result or a different result in order to produce a result of liability. There it is. You can basically see what it's driving at. Now, does anyone have any questions? I can see the chat, but I can't actually at the moment. I've seen a few people saying hello to us, but I haven't actually seen any questions unless I'm missing something on the chat. I mean, if anyone does have any questions, please do feel free to ask if you have any points which you'd like to raise with us.
Hello.
Hello, yes.
Hi, yes, hello. It's Anna Lelliot. I do have a question actually.
Yes.
Because in the way that the 6 questions are framed, I wonder whether when you're setting out your claim right at the outset, whether actually those are the sort of questions that you should be answering, even when you're at the stage of writing a letter of claim, because they go through each stage, not in the usual order you would expect, but I just wonder whether that's what you would now see as a result of the recent cases, that actually you go and answer those questions, at the end of it you ask the counterfactual, rather than doing, duty breach, loss, etc., in the usual way.
Well, it's a nice question. I think these are sort of simply practical. I think the way the Supreme Court expresses it is these are sort of practical ways of looking at it. I don't think you'd be required to plead your case, so to speak, and say, I satisfy all 6 requirements, or in a statement of claim, particulars of claim, and I don't think you'd have to do that in a letter of claim. I think more really it's just a sort of guideline for practitioners and for judges to make sure that they're taking into account the relevant facts and matters. So I don't think it's intended to make a difference to the way you write your letters or do your pleadings. It's just more how you go about analysing the case. I mean, I dare say sometimes it might be quite useful to follow the 6 things through if there's real doubt about them. For myself, I think the most important point is the scope of duty point. I mean, all you really have to do is say the loss I'm claiming falls within the scope of your duty to save me harmless against. And if the counterfactual is too difficult, forget the counterfactual. Don't get into it, because it really can. It is very complicated, or can get very complicated. So I think the general advice would be for the claimant, keep it dead simple, say what the purpose of the duty is, say there's obviously a nexus between the breach of duty and the wrong and the loss suffered, and leave it to the defendant to say that you've got to come up with some crazy counterfactual, which means there's no liability. That'd be my way of dealing with it. I've got a question here from Tim Norman. Sara, would you like to deal with this? Doesn't this mean that the professional is now likely always now to have a more limited liability for loss, because the scope of the duty will rarely extend to the larger losses claimed by the claimant? In other words, his duty is reduced, was more limited than what you might have thought it was.
Well, Peter, I think perhaps to echo what you've just said, it's about making sure you think about the component parts of the claim. I don't think this necessarily means it is always going to be more limited. I just think there has been a bit of a tendency in professional claims I've seen over practice not to focus on scope of duty and rush into dealing of matters of causation, and very quickly, if you're acting for the claimant, getting entangled in some very complicated counterfactuals, as you've said. So I don't think it necessarily becomes more limited, but there needs to be some clarity over it and exactly what is included and what falls outside.
Yes, I think it's fair to say that both cases emphasise the need. It is absolutely vital that the loss claimed can properly be said to fall within the scope of the duty. And the majority judgment in the Manchester case make that point about 50 times. It's almost as if they got the word processor out and keep on putting it in different parts of the judgment. And I think that might be something which could potentially limit, or at least make people more aware of the limitations of liability on the profession than they had been before. And sorry, while we're waiting, can I just ask you a question? Was the Khan decision seen in the clinical negligence world as a harsh decision, or probably as the right one? I mean, for myself, when I read the facts without knowing the answer, I wasn't quite sure what the right answer was. It just seemed a bit rough somehow.
And Peter, I think the reactions range from thinking it was harsh to slight horror, actually, in some court. And some of the judgments try, or some of the analysis of the judgments try and warn people in the personal injury community that it could be affecting them. So I think you're absolutely right. And I do think what Lord Leggett has said is going to be something that people will really grab onto, that there will be certain types of expertise that mean that you may not specifically be asked for something, but that you will be expected to kind of cover it because it is so material.
So something, even if let us say, the patient hasn't asked for advice on something, and so strictly speaking, it doesn't fall within, or on the face of it, it doesn't fall within the scope of the doctor's duty of care. Nonetheless, if it's something the doctor himself ought to be thinking about, then it does fall within the scope of his duty of care. Is that right? And so if, let's say, it was known that sometimes there was a connection between autism and haemophilia, perhaps the negligent doctor, Mrs. Khan, should have said, by the way, as it were, I ought to let you know that if your son does suffer from haemophilia, then there's also an increased risk of autism. Is that how it would work?
Yes, but you would be relying on Lord Leggett, who has gone out on a bit of a limb on that, though almost all of the commentary I saw had leapt on this particular bit of the judgment in Conor Meadows. So I wonder if there will eventually, over the coming years, be certainly clinical negligence cases that try and rely on that to kind of distinguish slightly.
Yes, yes. I mean, where the facts very unusual, Khan, they're terribly stark. And isn't normally the case that, you know, illnesses are related. And you can normally get some doctor to say that if you fail to spot illness A, there's a good chance that illness B will come along as well.
I think that's absolutely right, because if you read the Supreme Court judgment, after dealing with Manchester, which they say is very complicated, they do almost with relief say the facts are very simple in Conor Meadows. And I think that with other types of more complex cases, you'll see room for perhaps more nuance, or certainly different findings of fact that would allow them to kind of depart.
Yes, yes. Good. But does anyone else have any questions which would like to ask us on chat, or indeed by raising a hand, which I see that you can do also, and I think has already been done? Would anyone like to raise a hand just to ask us one final question, perhaps, before we wind up? I think in those circumstances, what I propose to do is to wind proceedings up and first of all say thank you very much indeed to all those attending. And we hope that you have at least been brought up to date a little on the rather complicated area of the law, which is actually terribly important in all professional negligence claims. Mm-hmm. And I might add, potentially in other claims. They do say in the Manchester case that this analysis of working out what's in the scope of the duty of care could also be important in more general commercial cases. And they refer to one or two other commercial cases where it could be important. And so it is worth being aware of this general notion that the question is not simply about remoteness or mitigation or novus actus interveniens. The question is also a rather different question, namely, what loss falls within the scope of the defendant's duty? And you can divide that loss up, even though there is actually only one loss in real life. And it is an important point, I think, to bear in mind, especially if you're acting for the defendant when you're trying to minimize your losses. I would also like to say thank you very much indeed to Sara for an extremely lucid talk on what I found as a particularly tragic case. And I know that if I'd been a judge, I'd have done my utmost, like the first instance judge did, to find a way for poor old Mrs. Meadows. But there it is, the law's tough, I suppose. Good. Well, with that, I'm going to wind up proceedings and say goodbye to everyone. And we can take it from there. We look forward to seeing those of you who we do see, who can see in the course of our professional practices in the very near future. Thank you very much indeed.